All right, this is page 28, and I'm starting with BPD stops pedestrians without reasonable suspicion. Our investigation reveals a widespread pattern of BPD officers stopping and detaining people on Baltimore streets without reasonable suspicion that they are involved in criminal activity. This conduct violates the Fourth Amendment, which allows police officers to briefly detain an individual for investigation where the officer possesses reasonable suspicion that the person is involved in criminal activity. It's called a Terry stop. Terry v. Ohio, 1968. To satisfy this standard, officers must be able to point to specific and articulable facts supporting an inference of criminal activity, and unparticulated suspicion or hunch is insufficient. You can't guess that somebody's doing something. You need proof. Terry particularity requirement is not satisfied where an officer deems a person to be acting suspiciously but fails to explain the specific basis of that suspicion. The officer must do more than simply label a behavior as suspicious to make it so. Rather, the officer must also be able to articulate why a particular behavior is suspicious. Then it gives a bunch of federal cases that back that up. Standing alone, an individual's unexplained presence in a high crime area is not sufficient to establish reasonable suspicion. Illinois versus Waldrol, the year 2000. It found that officers lacked reasonable suspicion to stop a man who was present in a high crime area late at night, acting nervously and conducting himself in a way that seemed inconsistent with his stated reasons for being at the location. Nor is an individual's decision to move away from police in a normal, unhurried manner reason to stop someone. All right, I suggest that you review page 28 because it's going back and forth between the various cases that are supporting what it's saying. The cases discussed in this section involve situations in which BPD's officers' descriptions of an encounter indicated that the person stopped was not free to leave and reasonable suspicion was therefore required, but it wasn't there. BPD officers routinely violate these standards by detaining and questioning individuals who are sitting, standing, or walking in public areas, even where officers have no basis to suspect them of wrongdoing. That reminds me of a case in Minneapolis, Minnesota, where a black father was sitting on a bench outside of a bank, but within the building was a school that his daughter attended, and the police violated his constitutional rights because he was sitting there minding his own business, not even acting suspicious, and they hassled the guy to the point of provoking him and then arresting him for what charge? Trespassing and resisting arrest. Right. Okay, anyway, let me jump back to this. The lack of sufficient justification for many BPD's pedestrian stops is underscored by the extremely low rate at which stops uncovered evidence of criminal activity. In a sample of over 7,200 pedestrian stops reviewed by the Justice Department, only 271, or 3.7%, resulted in officers issuing a criminal citation or arrest. Expressed a different way, BPD officers did not find and charge criminal activity in 26 out of every 27 pedestrian stops. Such low hit rates are a strong indication that officers make stops based on a threshold of suspicion that falls below constitutional requirements. A finding that a hit rate of 12% in pedestrian stops indicated that the stops were not supported by reasonable suspicion, and that's Floyd versus City of New York, 2013. Despite the low rate of stops uncovering evidence of crimes, BPD supervisors often direct officers to make frequent stops as a crime suppression technique. Many of the unlawful stops we identified appear motivated, at least in part, by officers' desire to check whether the stopped individuals have outstanding warrants that would allow officers to make an arrest or search individuals in hopes of finding illegal firearms or narcotics. All right, then I'm going to jump to Various court cases held that search incidents to arrest were valid based on the discovery of an arrest warrant, even when initial stop was unconstitutional because the stop was an isolated incident of negligence and there was no indication that this unlawful stop was part of any systematic or recurrent police misconduct. Then Sotomayor, and that was a Supreme Court case with Sotomayor dissenting. It also stated, warning that police may make unlawful stops in hopes of uncovering outstanding warrants, subjecting individuals to humiliation and indignity is wrong. That's what she wrote. Indeed, where individuals lack identification, allowing officers to check for warrants, officers sometimes detain and transport them to booking facilities to check their identification via fingerprinting, and unconstitutional detention where officers have reasonable suspicion to make initial investigative stop. All right, and then it references another court case. See, and what happens here is, even when they know they got nothing on you, they know they have nothing on you, they're attempting to get you into the system, because once your records are in the system, they pretty much have done their job. Okay, now I'm going to pause it here for a moment. Okay, here's an example of an officer's own report that basically documents his unconstitutional conduct. Excuse me. Officers' own reports describe this facially unconstitutional conduct. For example, an officer in the Northeast District noted in an incident report that he observed a 22-year-old African-American male walking through an area known to have a high rate of crime and drug activity. After watching the subject turn into an alley, the officer, despite possessing no specific information indicating that the man was involved in criminal activity, stopped and questioned him. The officer's report does not identify any evidence of wrongdoing uncovered during the Terry stop. Nonetheless, the report explains that the officer transported the man to BPD's Northeast District headquarters to properly identify him because the subject was reluctant to give any information about himself or his actions. After this custodial detention likewise uncovered no evidence of wrongdoing, the subject was finally released. This stop lacked reasonable suspicion at the outset, far exceeded the temporal limits even for valid Terry stops, and violates BPD's policy requiring officers to contact supervisors when a Terry stop lasts for more than 20 minutes. But a BPD supervisor nonetheless signed off on the incident report describing this unlawful stop and detention. In some cases, unconstitutional stops result from supervisory officers' explicit instructions. During a ride-along with Justice Department officials, a BPD sergeant instructed a patrol officer to stop a group of young African American males on a street corner, question them, and order them to disperse. When the patrol officer protested that he had no valid reason to stop the group, the sergeant replied, "Then make something up." This incident is far from anomalous. Okay. Specifically on that one, that make stuff up stuff happens all the time. And even when you have a decent cop that knows that he shouldn't do it and doesn't want to do it, supervisors can force people to do stuff that they don't actually want to do. All right, back to the report. A different BPD sergeant posted on Facebook that when he supervises officers in the Northeast District, he encourages them to clear corners, a term many officers understand to mean stopping pedestrians who are standing on city sidewalks to question and then disperse them by threatening arrest for minor offenses like loitering and trespassing. The sergeant wrote, "I used to say at roll call in Northeast when I ride the shift, do not treat criminals like citizens. Citizens want that corner cleared." Indeed, countless interviews with community members and officers describe corner clearing scenarios in which BPD officers stop, question, disperse, or arrest individuals in public areas based on minimal or no suspicion of highly discretionary offenses. Such unlawful stops erode public confidence in law enforcement and escalate street encounters, sometimes resulting in officers deploying unnecessary force or committing additional constitutional violations. For example, on a cold January evening in 2013, an officer approached and questioned an African American man crossing the street in a high crime area while wearing a hooded sweatshirt. The officer lacked any specific reason to believe the man was engaged in criminal activity, but according to the incident report prepared by the supervisory officer on the scene, the officer thought it could be possible that the individual could be out seeking a victim of opportunity. This unsupported speculation furnished no basis to conduct a stop. Nonetheless, multiple officers questioned the man and seized a kitchen knife that the man acknowledged carrying. When the man asked the officers to return his knife, the officers ordered the man to sit down and then forced him to the ground. When the man persisted to ask for his knife, the man yelled, "You can't arrest me," and resisted his detention. Although there was no basis to detain the man, two officers attempted to handcuff and shackle him, while one officer struck him in the face, ribs, and back with fists. The man continued to resist being shackled as additional officers arrived, one of whom tased the man twice to prevent him from escaping the scene. After officers handcuffed the man, they transported him to Union Memorial Hospital for medical care. The man was not charged with any offense. The sergeant who responded to the scene confirmed that the involved officers tased the man twice and hit him in the face with their fists, yet the sergeant's report of the incident concluded that the officers showed great restraint and professionalism. That pisses me the fuck off. I'm sorry. In summary, we find that BPD officers frequently stop pedestrians on Baltimore streets without reasonable suspicion that they are engaged in criminal activity. This pattern is evidenced by the extremely low rate at which BPD's investigative stops yield evidence of criminality and officers' own descriptions of their conduct. The frequency of these unlawful stops subjects certain Baltimore communities to repeated constitutional harms. BPD searches individuals doing stops without legal justification. During pedestrian and vehicle stops, BPD officers regularly escalate encounters by conducting unlawful searches. This practice includes two types of conduct: officers conducting weapons pat-downs or frisks where they lack reasonable suspicion that a subject is armed and dangerous, and two, pre-arrest strip searches in public areas. Both types of conduct result from systematic deficiencies in policy training and oversight. Unconstitutional frisks. BPD officers commonly frisk people during stops without reasonable suspicion that the subject of the frisk is armed and dangerous. This practice contravenes the principle that before an officer places a hand on the person of a citizen in search of anything, he must have constitutional, adequate, reasonable grounds for doing so. Before frisking a person stopped on the street or in a vehicle, officers must have reasonable suspicion. This requirement is distinct from the justification needed to make the underlying stop. Whether a lawfully detained person may be armed and dangerous and thus subject to a Terry frisk, the assessment of reasonable suspicion to frisk is based on the totality of the circumstances. It is insufficient standing alone that a person has a prior record of arrest for violent charges, was stopped in a high crime area, or was stopped late at night. Where reasonable suspicion to conduct a frisk exists, officers must limit the scope of the search to a pat-down of the outer layers of the suspect's clothing. Once an officer establishes that a person is not armed, that officer exceeds the permissible scope of a Terry frisk if he continues to search the suspect. The officer is not allowed to do anything such as squeezing, sliding, or otherwise manipulating the contents of a defendant's pocket after determining that that pocket did not contain a weapon, period. Yet for many years, suspicionless frisks have been a common feature of BPD's street enforcement efforts. Officers and community members told Justice Department investigators that frisks often made under the guise of officer safety, but without identifying any specific basis for believing that a person is armed, are a common feature of BPD stops. Officers' own descriptions of frisks in their incident reports support this conclusion. For example, on a spring evening in 2010, officers responded to a call complaining that drug sales were occurring in a particular location. Excuse me. Officers arrived at the scene and observed several African American individuals standing and sitting at the location. Absent information that the individuals were armed or otherwise dangerous, the officers nevertheless approached and immediately frisked them. Officers disclosed the frisk in an incident report, explaining that they performed the frisk for officer safety. Although the officers provided no information that suggested the individuals were armed or dangerous, BPD supervisors signed off on the report. Our review of incident reports and interviews with several hundred community members indicate that the unconstitutional frisk practice is widespread. We were unable to precisely quantify the scope of these unconstitutional frisks, however, because BPD does not reliably record when officers conduct a frisk. BPD's misapplication of the Terry frisk standard subjects Baltimore residents to embarrassing invasions of privacy and needlessly escalates encounters with law enforcement. In one particular case, a BPD officer unlawfully frisked an African-American man after a traffic stop for driving with headlights off. Because the driver looked nervous as the officer approached, the officer ordered the driver and his passenger to exit the vehicle and stand on the side of the road. The officer then frisked the passenger, which included a public pat-down of the passenger's groin. The officer identified no basis for frisking the passenger other than the driver's nervous appearance, far short of the required showing of particularized facts pointing to the presence of a weapon. No reasonable suspicion to frisk the man during a vehicle stop for a burned out light, even when officers had information that the man had prior arrests for armed robbery. In another incident, the officer approached an African-American man walking on a sidewalk in November 2010 in an area the officer stated was known for violent crime and narcotics distribution. When the officer attempted to interview him about his activities, the man fled. According to the report the officer filed the day of the incident, he chased the man and deployed his taser because the man refused to comply with his orders to stop. The taser prongs hit the man on the back but failed to stop him. As the chase continued, the officer reloaded his taser cartridge and fired probes into the fleeing man's back. After catching up with the man, the officer used his taser yet again, this time in drive stun mode, detained the man for investigation and conducted a weapons frisk. The report provided no reason to believe the man was armed. The frisk and investigation found no weapon or other evidence of wrongdoing. The man, after being tased multiple times, taken to the ground and frisked, was released without charges. Even where BPD officers properly initiate a frisk based on reasonable suspicion that a person is armed or dangerous, we found instances in which the scope of these frisks exceeded the brief pat-down of the outer layers of the suspect's clothing that Terry prescribes. BPD officers commonly frisk individuals in a way that seems intended to find small packages of narcotics rather than weapons. In cases reviewed by the Justice Department, officers reached inside of subjects' clothing, asked subject to remove articles of clothing, and squeezed pockets to detect small bags that may contain illegal drugs. Okay, I'm going to stop it here and pick it up in the next video.